Constitutional Power and the Partisan Activism of Leftist Judges, by Gregory O'Grady. In recent years, judicial activism has increasingly shaped the political landscape, particularly through interventions by left-leaning judges who seek to influence executive authority. The phenomenon has become more pronounced with the election of conservative leaders, such as former President Donald Trump, who has faced numerous judicial roadblocks from unelected judges who appear more aligned with political ideology than with constitutional principles. The current legal battle surrounding Trump's second presidency illustrate a concerning shift in the balance of power among the three branches of government, where courts are encroaching on the executive's Article II powers. This trend raises fundamental questions about judicial overreach, partisanship, and the true nature of constitutional crises. The recent media narrative, particularly from left-leaning outlets like CNN, has framed Trump's legal disputes as a constitutional crisis, suggesting that his administration is unlawfully defying court orders. However, this characterization ignores a deeper and more troubling reality: the increasing use of the judiciary as a tool for political obstruction rather than a neutral arbiter of law. The Constitution divides powers among the branches of government, and while judicial review is a crucial mechanism for upholding the law, courts stepping beyond their defined role to micromanage executive actions present a greater constitutional threat than any single administration's policies. The idea that a president must be beholden to every lower court ruling, regardless of its legal merit or constitutional basis, distorts the foundational principles of checks and balances. A glaring example of this judicial interference is the recent injunction issued by District Court Judge John McConnell, an Obama appointee, which accused the Trump administration of violating a prior order to unfreeze federal funds. The original memo from the Office of Management and Budget merely directed a temporary pause on federal grants and loan programs to conduct a compliance review. When a court initially blocked this pause, the administration complied and rescinded the memo. Yet, McConnell's ruling went beyond the original dispute, expanding the order to prohibit the White House from pausing any form of federal spending, even in cases where such pauses were legally authorized. This move effectively stripped the executive branch of its ability to conduct financial oversight, a fundamental responsibility of the presidency. Rather than adjudicating an actual constitutional conflict between branches, the court appeared to be inserting itself into policy decisions simply because it opposed the administration's approach. Another striking example occurred in New York, where District Court Judge Paul Engelmayer, another Obama-appointed judge, issued an order restricting political appointees from accessing Treasury Department data. The justification for this ruling rested on concerns that sensitive financial information might be leaked, an assumption rather than a proven violation. This ruling effectively dictated internal operations within the executive branch, preventing even the Treasury Secretary from overseeing data access within his own department. Such judicial micromanagement of executive agencies represents an unprecedented overreach that erodes the separation of powers. While courts have a role in ensuring that executive actions align with congressional statutes, extending that authority to dictate daily administrative functions goes beyond their constitutional mandate. The broader issue at play is not whether the president, whether Trump or Biden, has absolute authority over policy, but whether the judiciary is overstepping its role as an impartial arbiter. Throughout Trump's presidency, numerous Democrat-led states, particularly their attorneys general, have engaged in forum shopping, seeking out activist judges in left-leaning jurisdictions such as New York, Rhode Island, and Washington, D.C., to block policies they politically oppose. This tactic ensures favorable rulings from judges who prioritize ideology over constitutional fidelity. These cases often lack direct harm to the plaintiffs, raising serious questions about legal standing. The supposed injuries cited in these lawsuits are often speculative, based on hypothetical future harms rather than actual violations of the law. This growing judicial activism reflects a broader democratic strategy to circumvent the electoral process when they fail to achieve their policy goals through legislation. Rather than working within the democratic system to persuade voters and win congressional majorities, the left has increasingly relied on courts to impose their political agenda. The irony is that while leftist politicians and media figures decry Trump as a dictator who disregards legal authority, his administration has consistently followed proper legal channels to challenge rulings through the appeals process. In contrast, Democrats have actively encouraged defiance of court decisions that do not align with their agenda, as seen in their reactions to Supreme Court rulings on issues like abortion and gun rights. The double standard is evident in their shifting rhetoric. When courts rule in their favor, they are the protectors of democracy. When courts rule against them, they are threats to democracy. This hypocrisy was on full display when Senator Chris Murphy, while warning of Trump's supposed lawlessness, admitted that the administration had largely complied with court orders. The Democratic strategy, therefore, appears less about defending democratic institutions and more about ensuring that power remains concentrated in their hands. The real constitutional crisis lies not in Trump's refusal to bow to judicial overreach, but in the increasing weaponization of the courts by political activists disguised as judges. Ultimately, constitutional power is not defined by partisan interpretations, but by the founding principles that created the balance of authority among the three branches of government. Courts do not exist to dictate policy. They exist to interpret the law as written. When leftist judges take it upon themselves to overrule presidential authority based on political preferences rather than constitutional guidelines, they undermine the very democracy they claim to protect. The judiciary should not serve as an unelected legislature, and when it does, it is not the executive branch that threatens democracy, it is the courts themselves.